I have spent decades listening to people explain why they believe they are right. Some come prepared, some come confused, some come desperate, but every now and then, someone walks into my courtroom already convinced they know more than everyone else, including the judge. And I still remember the day a woman named Karen Prescott sat across from me, carrying a stack of highlighted legal printouts, interrupting every sentence, correcting everyone in the room, and acting as if the courtroom existed solely to confirm her opinions. She thought she knew the law. She thought she knew the rules. She thought she knew exactly how the hearing would end. What she did not know was that one overlooked document buried deep inside her own evidence would destroy her entire case. And believe me, the moment she realized it, the expression on her face was unforgettable. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now, let me take you back to where this case truly began. The plaintiff was a man named Michael Turner, 47 years old, owner of a small construction company, calm professional, the kind of person who speaks only when necessary. Across from him sat Karen Prescott, 42 years old, immaculately dressed, 3 binders, 2 notebooks, a folder filled with printed statutes and legal articles. The moment she entered the courtroom, I knew she intended to be her own attorney. That wasn't unusual. What was unusual was how quickly she began acting like everyone else's attorney, too. Years on the bench teach you that confidence and competence are not the same thing. Karen seemed to believe they were. The dispute involved a home renovation project. Michael claimed Karen hired his company to renovate her kitchen, approved every phase of the work, signed completion documents, and then refused to pay the final invoice. The unpaid balance was $53,000. Karen claimed the work was defective. At least that was her official position. Unofficially, her position seemed to change every 5 minutes. I asked Michael to explain the project. He stood calmly and presented photographs, contracts, inspection reports, permit approvals. Everything appeared organized. Karen interrupted before he finished his second sentence. That's legally irrelevant. Interesting, very interesting. I looked at her as Prescott. You will have an opportunity to speak, but the law doesn't support what he's saying. You will have an opportunity to speak. She leaned back dramatically, clearly irritated. That observation mattered, because people who genuinely understand legal procedure rarely feel compelled to announce it every 30 seconds. People trying to appear knowledgeable often do. Michael continued. He explained how Karen selected premium materials, approved change orders, expanded the project scope twice, and repeatedly complimented the work during construction. Karen interrupted again. Objection. The courtroom became silent. I stared at her. Interesting, very interesting, because this wasn't a trial with attorneys making formal objections. And even if it had been, the objection made no sense. Karen paused, then said, "Hearsay." Several spectators exchanged looks. Michael looked confused, honestly. So did Karen. That was obvious. Years on the bench teach you that people who misuse legal terms often reveal more than people who never use them at all. I asked her to explain why the statement was hearsay. She couldn't, not clearly, not correctly, not convincingly. That told me something important. Karen didn't understand the law. She understood legal vocabulary. Those are very different things. Then she opened one of her binders. And that's when the performance truly began. For the next 10 minutes, Karen quoted statutes, referenced legal websites, mentioned appellate decisions, repeated legal phrases. Everything sounded impressive, at least until you examined it. because every citation had the same problem. None of them applied. Interesting, very interesting. I remember thinking something very simple. Karen had done research, a lot of research. The problem was that she researched answers instead of researching facts. People often make that mistake. They start with a conclusion, then search for information that supports it. That is not analysis. That is confirmation. And confirmation rarely survives scrutiny. Then Michael presented something unexpected. A collection of text messages, dozens of them, Moss exchanged throughout the renovation. I reviewed them carefully. The first few were ordinary scheduling, materials, delivery updates. Then I found something interesting, very interesting, a message from Karen, sent 3 weeks before the project finished. I read it once, then twice, then a third time, because the wording immediately caught my attention. I looked toward Karen. Did you send this? Her confidence remained intact. Yes, interesting, very interesting, because she had no idea what message I was looking at. I began reading. This kitchen looks better than I imagined. The courtroom became quiet. Michael said nothing. Karen immediately leaned forward. That was before I discovered the defects. Interesting answer. Not convincing, but interesting. Because now I wanted to know what defects she was talking about. I asked her. And for the next several minutes, she listed problem after problem. Cabinets, countertops, lighting, flouring paint. Everything. Apparently, the more she talked, the weaker her position became. Years on the bench teach you that genuine complaints are usually specific. Manufactured complaints often become endless. Karen seemed to have complaints about everything. Then I asked a very simple question. Did you hire an independent inspector? Silence. Interesting. Very interesting. Did you hire one? No. Did you obtain an expert report? No. Did any licensed professional conclude the work was defective? No. The courtroom became quiet because now we had a problem. Karen claimed catastrophic defects, yet she possessed no expert support, no inspection, no report, no evidence, only opinions, and opinions are not always enough. Then Karen smiled, actually smiled. That caught my attention immediately because people usually don't smile when their argument weakens, unless they believe they are holding something stronger. She opened another binder, removed a document, and proudly announced, I have the law on my side. Interesting, very interesting, because years on the bench have taught me that the people who say that most often usually don't. I accepted the document, reviewed the first page, then the second, then the third, and suddenly I noticed something Karen clearly hadn't, something hidden inside her own evidence. Something that would eventually make her regret every word she had spoken that day. The moment I started reading Karen Prescott's document, I stopped listening to her, not because I wasn't interested, because I was very interested. Years on the bench teach you that people often hide their biggest mistakes inside the evidence they believe will save them. And Karen had just handed me a very large stack of evidence. Confidently, almost proudly. That confidence caught my attention because confidence without verification can be dangerous, very dangerous. Karen sat back in her chair, smiling, clearly convinced she had just delivered the decisive blow. Michael Turner watched quietly. The spectators leaned forward, and I began reviewing the document. The first page appeared legitimate Doc Sommer protection guidelines. Interesting, the second page referenced contractor obligations. Also interesting, the third page contained highlighted sections. Lots of highlighting. Years on the bench teach you that excessive highlighting often signals something amusing. People highlight what they want others to see. Sometimes they accidentally highlight what they don't want others to see. Karen had done exactly that. I continued reading, then I found the section she clearly wanted me to focus on. A paragraph discussing defective workmanship. Interesting, very interesting. Karen immediately leaned forward. There, not an argument, just there. As though the existence of the paragraph settled everything, I looked at her. What specifically about this provision helps your case? Karen smiled again. It says homeowners aren't required to pay for defective work. Interesting answer, not wrong, but incomplete, very incomplete, because legal provisions rarely exist in isolation. I kept reading. Then I reached the next paragraph. The paragraph Karen apparently skipped. That caught my attention immediately. Years on the bench teach you that people who believe they understand the law often stop reading as soon as they find language they like. That habit gets them into trouble. Frequently, I read silently. Then again, then a third time, because the wording was important, very important. I looked up. Karen was still smiling. That made the moment even more interesting. Mrs. Prescott, yes? Would you please read the next paragraph? The smile faded slightly. Interesting. Very interesting. She took the document, read silently, then stopped. The room became quiet. I waited. Karen kept reading, then reading again, then reading a third time. Years on the bench teach you to watch people when they discover something unexpected. The reaction is often subtle. A slight change in breathing, a shift in posture, a sudden loss of confidence. Karen displayed all three. Interesting. Very interesting. I asked her a simple question. Would you like to read it aloud? A pause. Then, no. The spectators exchanged looks. Michael remained silent. I already knew why Karen didn't want to read it. Because the paragraph immediately following her highlighted section stated something devastating. Consumers must provide contractors a reasonable opportunity to inspect and correct alleged defects before withholding payment. Interesting, very interesting. Because Karen had already admitted she never did that. No inspection request, no repair request, no correction request. Nothing. The room became silent. Karen immediately attempted recovery. That doesn't apply here. Interesting answer. Not convincing, but interesting, because now we were moving away from facts and toward improvisation. I asked why it didn't apply. Karen began flipping through papers, lots of papers. The problem was that none contained an answer. Years on the bench teach you that people often confuse activity with effectiveness. Karen was extremely active. She was becoming less effective by the minute. Then Michael submitted another document, a certified letter. Interesting, very interesting. I reviewed it carefully. The letter was sent 3 days after Karen refused final payment. It offered a complete walkthrough, a full inspection, repairs if necessary, adjustments if necessary, corrections if necessary. Everything required under the contract, everything required under the guidelines Karen herself submitted. I looked toward Karen. Did you receive this? A pause. Then, yes. Interesting. Very interesting. Did you respond? No. The courtroom became quiet, not dramatic, just quiet, the kind of silence that arrives when a position begins collapsing under its own weight. Then I found another letter, then another, then another, each offering inspection, each offering correction, each ignored. Interesting. Very interesting, because now a pattern was emerging. And patterns matter. A lot. Years on the bench teach you that one missed communication may be accidental. 4 ignored communications become a decision. Karen was beginning to look uncomfortable. That observation fascinated me, because earlier she seemed eager to discuss the law. Now the law was becoming a problem. Then I found something even more interesting, an email sent by Karen herself. Only 2 days after refusing payment, I read it once, then twice, then a third time, because the wording immediately caught my attention. I looked toward her. "Did you write this?" Her expression changed. Immediately interesting, very interesting, because now she recognized the document and she already knew what it contained. "Yes." The answer sounded weaker than earlier answers, much weaker. I began reading. "Do not let them back into the house." The room became silent. I continued. "If they inspect anything, it will hurt our leverage." Nobody moved. Nobody spoke. Even Karen remained silent, because there it was, not confusion, not frustration, strategy, documented strategy. Years on the bench teach you that motive often hides behind procedure. Karen wasn't trying to solve a problem. She was trying to strengthen a dispute. That distinction matters a lot. Then I noticed something else in the email chain. A recipient, not Michael Turner, not a contractor, not a lawyer. Someone else, a woman named Rebecca Collins. Interesting, very interesting. The same Rebecca appeared repeatedly throughout Karen's messages. I reviewed the conversation history. Then another message caught my attention. And honestly, the moment I read it, I knew this case was about to become much bigger than a renovation dispute, because according to Karen's own words, she never intended to pay the final invoice. And she wrote that weeks before the renovation was even finished. The moment I realized Karen had discussed withholding payment before the renovation was even completed, the entire case changed. Not gradually, immediately, because there is a significant difference between refusing to pay due to defects and planning not to pay before you even know whether defects exist. Years on the bench teach you to pay attention to timing. Timing reveals motive, and motive often reveals the truth. The courtroom remained silent. Karen looked uncomfortable. Michael Turner looked curious. The spectators sensed something important had happened. They simply didn't know what yet. I reviewed the email again, then another time, because I wanted to be absolutely certain the timestamp was clear. The renovation still had several weeks remaining, yet Karen had already written, "There's no way I'm paying the final balance." Interesting. Very interesting. I looked toward her. "Did you send this message?" A long pause followed. Then, "Yes." The answer barely escaped her mouth. Interesting. Because confidence was disappearing now rapidly, the woman who entered the courtroom correcting everyone had become noticeably cautious. That observation mattered a lot. I continued reading. The next sentence caught my attention immediately. "I just need a legal reason." The room froze. Absolute silence. Michael slowly lowered his head. The spectators exchanged stunned looks. And honestly, even after years on the bench, I still find it remarkable how often people document their intentions. Karen apparently never expected those messages to appear in court. Now they were. And they were speaking much louder than she was. I looked directly at her. "What did you mean by that?" Karen immediately shifted in her chair. Interesting, very interesting, because she didn't answer. Not immediately. People who tell the truth often respond quickly. People searching for safe answers usually need time. Karen needed time, a lot of it. Finally, she spoke. "I was frustrated." Interesting answer. Not convincing, but interesting, because frustration does not usually cause someone to search for legal reasons not to pay. Planning does. I asked another question. "Were there defects at the time you sent this message?" Silence. Then no. The room became quiet, not dramatic, just quiet. The kind of silence that arrives when someone accidentally destroys their own argument, because now we had a problem. Karen claimed she refused payment because of defects. Yet weeks earlier, she planned to refuse payment before any defects allegedly existed. Interesting, very interesting. Then I noticed something else. The recipient, Rebecca Collins. I returned to that name. because it kept appearing again and again and again. Years on the bench teach you that repeated names often matter a lot. I reviewed additional messages, then another, and suddenly Rebecca's role became clearer, very clear. I looked toward Karen. Who is Rebecca Collins? The reaction was immediate, too immediate. Her eyes widened. Her posture stiffened. Interesting, very interesting, because that reaction alone suggested Rebecca was important, very important. Karen hesitated, then answered, "A friend." Interesting answer. Not necessarily false, but incomplete. Years of courtroom experience have made me highly suspicious of incomplete truths. They usually exist to avoid larger truths. I reviewed the records again. Then I found a message that changed everything. A message sent only 4 days before the renovation finished. I read it once, then twice, then a third time, because the wording was extraordinary. I looked toward Karen. The color had already begun disappearing from her face. She knew. She absolutely knew. "Did you send this?" Silence, then, "Yes." I began reading. Rebecca says contractors always settle if you pressure them long enough. The room became silent. I continued. "Nobody spends thousands fighting over the last payment." Interesting. Very interesting. Because suddenly Karen's strategy was becoming visible, not defects, not quality concerns. Pressure, that distinction mattered a lot. Michael remained silent, but I noticed something. He wasn't surprised. That caught my attention immediately. Years on the bench teach you that people react when hearing new information. Michael didn't. Interesting, very interesting. I turned toward him. "Have you seen these messages before?" "No." Interesting, very interesting, because he wasn't reacting like someone discovering them. He was reacting like someone confirming something he already suspected. That observation stayed with me. Then I reviewed additional communications. And that's when I found something truly strange. Rebecca Collins wasn't simply giving advice. She was sharing examples, specific examples, contractors, disputes, payment conflicts, settlement strategies. Interesting, very interesting. The more I read, the more uncomfortable I became, because Rebecca seemed remarkably familiar with this process, too familiar. Then I found a message from Rebecca herself. Only one sentence, but enough. More than enough. I read it once, then twice, then a third time, because I wanted to be absolutely certain. I slowly looked up. Karen had gone pale, completely pale. That reaction told me plenty. I began reading. "Used the same method we used on the landscaping company." The room froze, almost silence. Nobody moved. Nobody spoke. Michael stared at Karen. The spectators exchanged shocked looks. And suddenly, the renovation dispute wasn't the only dispute anymore. Interesting, very interesting, because now another company existed. Another conflict existed. Another possible pattern existed. Years on the bench teach you that patterns are rarely accidental. One dispute may be a misunderstanding. Multiple disputes often become something else. I looked toward Karen. "Which landscaping company?" Silence. Ms. Prescott. Another silence. Then "I don't remember." Interesting answer. Very interesting answer, because people often forget details that become dangerous, yet somehow remember details that help them. That pattern rarely improves credibility. Then I reviewed the final attachment in the message chain, and honestly, the moment I opened it, I knew the case was about to explode, because the attachment wasn't a conversation. It wasn't a contract. It wasn't a legal article. It was a settlement agreement from a completely different dispute. And according to the signatures, Karen Prescott had been involved in it. The moment I saw Karen Prescott's name on the settlement agreement, the entire atmosphere inside the courtroom changed. Not because prior disputes automatically prove wrongdoing. They don't. but because patterns matter, and Karen was beginning to develop one. Years on the bench teach you that a single incident can be explained. Repeated incidents require examination. The courtroom remained silent. Karen stared at the table. Michael Turner sat quietly. The spectators leaned forward. Everyone could feel the case shifting. I reviewed the settlement agreement carefully, then again, then a third time, because details matter. The agreement involved a landscaping company, a family-owned business. Interesting, very interesting. The dispute occurred nearly 2 years earlier. Karen hired the company. The company completed the work. Karen refused final payment. The company threatened litigation. The matter eventually settled. Interesting, down familiar. It should, because it looked remarkably similar to the dispute sitting in front of me. I looked toward Karen. Were you involved in this matter? A long pause followed, then, yes, interesting. Very interesting, because now we had confirmation, not speculation, not rumor. Confirmation. I asked another question. Did you claim the landscaping work was defective? Karen hesitated. That hesitation mattered a lot. Then she answered, yes. Interesting, because I had already reviewed the settlement records, and according to those records, the landscaping company strongly disputed her allegations. The pattern was becoming difficult to ignore. Then I noticed something else, a specific clause buried inside the agreement. Interesting. Very interesting. I read it once, then again, then a third time, because it immediately caught my attention. The clause stated that neither party admitted wrongdoing. Ordinary language, very ordinary. But attached to the agreement was something much more interesting, a mediation summary. And that summary changed everything. I reviewed it carefully, then looked toward Karen. The color had begun disappearing from her face again. That reaction alone told me plenty. Years on the bench teach you that people often react to documents before anyone else understands them. Karen already knew what I was reading. I began reviewing the mediator's notes. Interesting, very interesting. According to the summary, Karen repeatedly refused inspection requests, repeatedly refused repair requests, repeatedly refused opportunities to resolve the dispute. Interesting, down familiar? It should, because that was exactly what happened with Michael Turner. The room remained silent. I turned toward Karen. Did you refuse inspection requests in the landscaping dispute? A pause, then, yes. Interesting, very interesting. The spectators exchanged looks, because now the similarities were becoming impossible to ignore. Two different companies, two different industries, the same behavior, the same strategy, the same pattern. Then I found another document, a very interesting document, one attached to the mediation records, an email. The moment I saw it, I knew things were about to get worse for Karen, much worse. I read it once, then twice, then a third time, because the wording was extraordinary. I looked toward her. The color had completely disappeared from her face. Interesting, very interesting. Because she knew exactly which email I had found. I asked a simple question. Did you write this? Silence. Then, yes. The answer sounded defeated, not defensive, defeated. That distinction mattered. I began reading. If they inspect the property, they'll fix everything. The room froze. I continued. If they fix everything, I lose leverage. Nobody moved. Nobody spoke. Even Michael looked stunned, because there it was. Agin, not frustration, not dissatisfaction. Leverage, the same word, the same strategy, the same thinking. Years on the bench teach you that repeated language often reveals repeated behavior. Karen wasn't describing problems. She was describing tactics. That difference mattered a lot. Then I looked toward Michael. For the first time all day, I saw something unusual, not relief, not satisfaction, recognition. Interesting, Very interesting. Because suddenly he understood that his dispute may never have been about renovation quality at all. It may have been about leverage from the very beginning. Then I found something even more disturbing. Rebecca Collins, interesting, very interesting. Her name appeared again, not once, several times. I reviewed additional communications, then additional records, and suddenly another picture emerged. A much larger picture, because Rebecca wasn't merely offering advice. She appeared involved in multiple disputes, multiple settlements, multiple payment conflicts that bothered me a lot. Years on the bench teach you that when the same names appear repeatedly across unrelated disputes, you should pay attention, very close attention. Then I discovered something hidden inside the metadata of the settlement documents. A file folder named SILB, ordinary, easy to miss. But I noticed it. The folder was labeled Contractor Playbook. Interesting, very interesting. The room became silent. I reviewed the contents, then another page, then another. And honestly, the more I read, the more concerned I became. Because this wasn't one dispute. It wasn't two disputes. It wasn't even three. The folder contained references to multiple businesses, contractors, landscapers, installers, repair companies. And beside each name were notes, tailed notes, strategies, settlement estimates, pressure points. The spectators had no idea what I was looking at yet. Karen did. That was obvious, because she looked absolutely terrified. Then I found the document that changed everything. A spreadsheet, a very detailed spreadsheet. I reviewed the first page, then the second, then the third. And slowly I realized something shocking. Karen wasn't simply keeping records of disputes. She was tracking outcomes, money saved, payments avoided, settlement amounts reduced, everything. I slowly looked up. Karen was staring directly at me, terrified, because according to the totals at the bottom of the spreadsheet, the amount she had avoided paying businesses over the last several years exceeded $300,000. I have seen people make bad decisions. I have seen people make expensive decisions. I have even seen people make decisions so reckless that they destroyed their own cases before they ever entered a courtroom. But what I was looking at now felt different, because this wasn't a single bad decision. It wasn't a misunderstanding. It wasn't a moment of poor judgment. It appeared to be a system, a carefully documented system. The courtroom remained silent. Karen Prescott sat completely still. Michael Turner stared at the spreadsheet. The spectators leaned forward. And I was looking at numbers that told a story Karen never intended anyone else to read. Interesting. Very interesting. The spreadsheet tracked disputes, not one, not two. Many contractors, landscapers, installers, painters, repair companies, cabinet suppliers, flouling specialists. And beside each entry appeared notes, settlement amounts, payment reductions, avoided balances, outcome percentages, everything. Years on the bench teach you that people often reveal their priorities through what they measure. Karen measured savings, not satisfaction, not quality. Savings, that distinction mattered a lot. I reviewed another page, then another, and suddenly something caught my attention, a category heading. Interesting, very interesting. The heading read, Successful Resolutions Successful. Not resolved, not completed, successful. The language bothered me because according to the spreadsheet, success seemed to mean paying less than originally agreed, sometimes much less. I looked toward Karen. She already knew where this was going. That much was obvious. The confidence from earlier had vanished completely. Now, she looked like someone watching years of preparation collapse in real time. Then I found Michael Turner's company listed in the spreadsheet. The room became silent. I reviewed the entry carefully. Then again, then a third time, because even after everything else, I wanted to be absolutely certain the notation beside Michael's company read, potential reduction target, 70%. Interesting. Very interesting. The spectators exchanged shocked looks. Michael lowered his head, and honestly, that reaction stayed with me because in that moment, he wasn't learning about construction defects. He was learning that someone had already calculated how much of his payment they hoped to avoid before the dispute even matured, before inspections, before complaints, before litigation. Interesting. Very interesting. I looked toward Karen. Would you like to explain this entry? Silence, then no. Interesting. Because for the first time all day, Karen wasn't attempting explanations. She wasn't attempting legal arguments. She wasn't quoting statutes. She wasn't pretending expertise. She had run out of places to hide. Years on the bench teach you that some people stop talking when they lose confidence. Others stop talking when they lose options. Karen appeared to have lost both. Then I found another worksheet. And honestly, this is where the case became unforgettable. The worksheet contained communication templates, pre-written messages, interesting, very interesting. I reviewed them carefully. The language felt familiar, extremely familiar. Then I understood why several messages were nearly identical to emails. Karen had already sent Michael Turner the same wording, the same complaints, the same phrases, the same accusations. Interesting, interesting, very interesting, because now it appeared the complaints weren't spontaneous. They were selected, prepared, repeated. The room became silent. I looked toward Karen. Did you create these templates? A pause. Then, yes. The answer sounded exhausted, not angry, not defensive. Exhausted, that observation mattered, because maintaining a complicated narrative requires energy. Karen had very little energy left. Then I found the document that created the viral courtroom moment people would discuss long after the hearing ended. A private note, never intended for court, never intended for public view. And judging by Karen's reaction, never intended to be discovered. I opened it. Write it once, then twice, then a third time, because even after everything else, I could hardly believe someone wrote it. I looked toward Karen. The color had disappeared completely from her face. Then I read it aloud. Most contractors panic when you mention lawsuits. The room froze. I continued. The trick is sounding like you know more law than they do. Absolute silence. Nobody moved, nobody spoke. Even Karen remained motionless because there it was. Not hidden, not implied, written, documented, directly connected to the very behavior everyone had watched throughout the hearing, the legal citations, the interruptions, the confident declarations. Everything. It wasn't knowledge. It was theater. Years on the bench teach you that genuine expertise usually speaks quietly. People pretending to have expertise often speak constantly. Karen had spoken constantly. Then I found the final section of the note. And honestly, even I wasn't prepared for it. I read it once, then again, then a third time. Because the wording was extraordinary. I slowly looked up. Karen was staring at the table. She couldn't even look toward me anymore. I began reading. If they ever challenge me in court, I'll overwhelm them with legal jargon before they realize I don't actually understand most of it. The courtroom exploded. Gasps, whispers, shock, actual shock. The court officer repeatedly called for order. Michael sat frozen. The spectators could hardly believe what they had heard, and neither could Karen, because for the first time all day, her own words had become the strongest witness against her. Then something unexpected happened. Michael reached into his folder, quickly, carefully, and produced one final document. A document nobody had discussed. A document Karen clearly didn't know existed. I reviewed the first page, then the second, then the third, and suddenly realized the spreadsheet wasn't the most damaging evidence in the room, not even close, because according to this new document, someone close to Karen had already exposed the entire scheme months earlier, and that person was about to become the most important witness in the case. I remember staring at that final document and realizing that Karen Prescott's case had reached a point of no return, not because of what Michael Turner said, not because of the spreadsheet, not because of the emails, because of who the document came from. Years on the bench teach you that evidence is powerful, but evidence from someone on the inside is often devastating. The courtroom remained silent. Karen sat motionless. Michael Turner looked exhausted. The spectators were completely invested now. Everyone could feel that the end was approaching. And I was holding a sworn statement signed months earlier by someone Karen trusted. Interesting, very interesting. I reviewed the first page, then the second, then the third. And slowly the entire picture became clear. The statement came from Rebecca Collins, the same Rebecca whose name appeared throughout Karen's messages, the same Rebecca who offered advice, the same Rebecca who appeared repeatedly in dispute after dispute. Interesting, very interesting, because Rebecca was no longer helping Karen. Rebecca was explaining Karen that distinction mattered a lot. According to the statement, Karen had developed a strategy years earlier, not to resolve disputes, not to improve projects, not to correct problems, to reduce payments repeatedly, consistently, deliberately. The room remained silent. I continued reading. Rebecca described conversations, planning sessions, templates, negotiation tactics, everything. And one sentence immediately caught my attention. Interesting, very interesting. The sentence read, Karen always said most small businesses couldn't afford to fight back. The courtroom became silent again, not because the statement was dramatic, because it explained everything. The landscaping company, the contractors, the repair businesses, the Michael Turner, everything. Karen wasn't choosing disputes. She was choosing targets. That realization bothered me. A lot years on the bench teach you that disagreements happen, legitimate disputes happen. But when someone begins selecting people based on their inability to defend themselves, that becomes something else entirely. Then I found another section. And honestly, this was the moment the entire courtroom understood who Karen really was. Rebecca described how Karen researched legal terminology. Interesting, very interesting, not legal concepts, not legal procedure. Terminology, words, phrases, perspectives, enough vocabulary to sound knowledgeable, not enough knowledge to understand what she was saying. And suddenly every interruption from earlier made sense. Every objection, every statute, every citation, everything. It was performance, not expertise. Karen thought sounding like a lawyer was the same as understanding the law. It wasn't. And now her own former ally was saying exactly that. The room remained silent. I looked toward Karen. For the first time all day, she looked defeated, not embarrassed, not frustrated, defeated. Years on the bench teach you that defeat looks different from disappointment. Disappointment questions the outcome. Defeat accepts it. Karen appeared to understand there was no recovering from this. Then I reached the final section of Rebecca's statement. And this is the part I still remember years later, because it connected directly to the title of this case. Rebecca wrote, Karen always believed judges would be impressed by confidence. Interesting, very interesting. Then came the next sentence, the sentence that changed everything. She never understood that experienced judges care about facts. The room became silent, absolute silence, because that was it. That was the entire case. Karen believed she could out-talk evidence, out-talk contracts, out-talk documents, out-talk facts. She couldn't. Nobody can. I turned toward Michael Turner. The man had spent months dealing with accusations, complaints, delays, excuses, yet he continued documenting everything, every email, every approval, every inspection, every communication. And because he did, the truth survived. That observation mattered more than many people realize. Facts often seem boring compared to arguments until facts win. Then they become very important. I reviewed the final records, the contract, the approvals, the change orders, the inspection opportunities, the refusal to allow corrections, the emails, the spreadsheet, the statement. Everything pointed in the same direction. Not defective workmanship, intentional non-payment. The evidence was overwhelming. I entered judgment in favor of Michael Turner. The unpaid balance, associated costs, the full amount supported by the evidence, still direct, scored by facts. Michael closed his eyes briefly. Relief, not celebration. Relief, the kind that arrives when someone finally stops carrying a burden. Then I looked toward Karen, the woman who entered the courtroom carrying binders full of legal printouts, the woman who corrected everyone, the woman who quoted statutes she barely understood, the woman who believed legal vocabulary could replace legal knowledge. Interesting how quickly certainty can disappear, because now she sat silently, no objections, no interruptions, no lectures. No statutes, no legal jargon, nothing, just reality. Years on the bench teach you something important. The law is not a collection of impressive words. It is a framework built around facts. Karen spent the entire hearing trying to sound knowledgeable. Michael spent the entire hearing presenting evidence. Only one of those approaches works consistently. As people began leaving the courtroom, I remained seated for a moment, reflecting, because some cases stay with you, not because they involve enormous amounts of money, not because they receive publicity, but because they reveal a simple truth. Karen thought intelligence meant sounding informed. Real intelligence means understanding what you actually know and what you don't. That distinction changes everything. Years later, I still remember the confidence she carried into that courtroom. And I still remember the expression on her face when her own documents started speaking against her. Karen thought she knew the law. She thought confidence would beat evidence. She thought legal jargon would beat facts. Instead, every word she spoke brought her closer to losing. And by the time the hearing ended, she had learned a lesson many people never do. The loudest person in the courtroom is not always the smartest, and the facts never care how confident you sound.